Hello, my name is Taylor Willingham, and I am a probate attorney here in Texas. And this video is based on what do you do when you're executor and administrator of an independent administration and you have to handle creditors. So usually when I'm getting asked questions about dealing with creditors is because people don't want to pay a creditor. The simple and easiest way to handle a creditor is to pay them if they're an actual creditor. You can actually have some problems if you pay somebody that is not an actual creditor. But the real question that people are usually trying to ask me is, I've received something and I'm supposed to pay this person, or can I avoid it? What do I do in these situations? And so I'm going to walk you through the rules about what you do under certain circumstances. Now, the first most important thing is you got to understand there are secured creditors and unsecured creditors. Okay. An unsecured creditor means it's a creditor that doesn't have some type of asset which they can take as collateral for non-payment of debt. So think of a car note. So if you owe money and there's a lien against the car, well, the car company has the right to take the car in for the loan. That's a secured debt. It was secured by something. Something holds on to that debt. The most common situation that you're going to face with a secured debt are mortgages. That is the most common. The most common unsecured debt is usually medical bills, or if you're dealing with credit cards. The last thing is also you got to understand anything I tell you here does not apply to taxes. Taxes have special rules on how to deal with it. If you have to pay taxes, you need to talk to your attorney about what you need to do with those taxes, especially if there's not enough money in the estate to pay taxes. Your attorney will probably have to deal with the IRS and work out some kind of arrangement. But right now we're just going to focus on unsecured and secured creditors. What do you do? All right, first off, if there is a secured debt creditor, you have to give them notice. All right, you are required within the first 2 months. A lot of times, though, my clients, they don't send any notice to the secured creditor because they're going to pay it off. If you're going to satisfy a debt for a creditor and there's no longer a creditor, well, then you don't have to give notice, right? There's no need to give notice because there's no more creditor. If you sell a house and pay off the mortgage, there's no more creditor. So there is no need to give the notice. The reason that you give this notice is if you plan to keep a house. That would be a very good example. You want to keep renting it out. We have 2 months to send a written request after you receive letters. You got to send it mail. Let them know there's certain information that you need to know. You need to tell them where they can send the claim. You should list out the attorney's office. You should list off yourself as the executor if your attorney's not doing this for you. A lot of times attorneys, you don't pay them to write a letter to a secure creditor because it's something easily can be done. The county that something is being probated in, the case number, you want to give them all the information that you possibly can about the case, and that gives notice. Now, what does that do? Well, the secured creditor now needs to come forward and present their claim. So they have some responsibilities that they have to do. Don't worry about their responsibilities. Just worry about your responsibility. Send the letter if you plan not to pay off the debt. So if you're going to keep a car, whatever it may be, you're required to send out this notice. Okay, that is basically secured creditors. That's how you deal with them. You have to send out that notice. Now let's talk about unsecured creditors. This is where we get a little, it gets a little bit more difficult. So what do we do with unsecured creditors? All right, something very important is to understand the two types of notices that are found in the code. Okay, first is the notice to creditors. That is section 308.051 of the Texas Estate Code. That is a requirement that you send the notice to creditors. So as almost all attorneys I know, they will do this for you. When you pay their fee up front, it is to do the notice to creditors too, because it has to be done. It is required by the court. So most of the time, your attorney is going to handle this for you. You want to make sure that your attorney is doing this for you, because the notice to creditors, it's just something that's filed in the newspaper. The attorney does this for you, and that it needs to be done within the 30 days of the letters being presented to you. It needs to get done. It is a requirement, but it really doesn't do anything. And that's why you need to understand that there's a different type of notice that does do some things. All right. So there's a thing called permissive notice. Okay. Permissive notice is found under, and let me read this to you, what it says. The independent executor, this is from the code, may give the notice to an unsecured creditor with a claim for money permitted under section 308.054 and bar a claim under section 403.055. What that means is if you want to bar a claim in the future, so you know that there's a debtor out there and you want to bar them from ever being able to collect it, after the notice is been presented, then there's 121 days. After the 120 days, if there's no claim filed by the unsecured creditor, it goes away. So in this situation, if you want to have that debt just go away, you can send permissive notice. Now, of course, if you send permissive notice, the unsecured creditor is going to present their claim within that 121 days. Well, not every creditor would, but most do, because they know that they have a time period that they have to do it under. A lot of times, when you're dealing with a creditor and you don't want to pay them, this is the step that you should take. If you receive no notice from the creditor, or you don't know that a creditor exists, then as long as you send the notice to the creditor, you're good. You're good to go. After the 60 days, so this is a very important rule. Once that notice creditor is filed, now let me talk about the timetable being an administrator here or an executor for just a second. The time point that usually things begin is when the judge signs the orders appointing you to be an independent executor, okay, or an independent administrator. Then usually time periods start for things. You have to file that notice to creditor within 30 days. The day you file the notice to creditors, there's 60 days you need to wait. 60-day waiting period to see if any claims come in. No claims come in, you can give the money to the beneficiaries. And usually it's good policy if you have received no notice to quickly get that done. Get the money out of the estate. Don't keep holding on to it because creditors can show up. They have 4 years to make a claim if you don't send permissive notice. Okay, so if you decide I'm not going to send permissive notice, let's say you get a claim in and I'm not going to pay it. Well, they have 4 years to file a lawsuit against you as the executor. Now, as the executor, as long as you didn't fraudulently, if they presented a claim and you didn't deal with it, then they can try to come after you personally for that. But if you had no notice of a claim, you can still be sued as the executor, but you're only sued as the executor and the estate will be responsible for the money. So it's not something to worry about in the sense of, oh, they're going to come after my personal assets. No, they can't come after your personal assets. You had no notice. You didn't know. So if you're confused, good, because this is a confusing thing. Because the question is, well, should I pay it? The answer is it's not easy. It's the choice that you have to make. Easiest way is if you get presented with a claim is negotiate the bill and pay it off, and then there's no more creditor. You're done. It's the easiest way to handle things. If you don't receive any notice, then you don't have any obligations to pay the claim if you just don't know about it. If you do know about it, for example, you know that they have a credit card debt and you kind of just ignore it, well, that could be a problem for you. It'd be kind of hard to prove that you knew it, but there are certain things you kind of want to pay attention to. So the answer to your question is yes, you have to deal with creditors if you are an executor or an administrator of the estate. Your attorney should be filing the notice of creditors for you. However, a lot of times attorneys aren't paid to do certain things, and so they're not going to do it because at the very beginning you went with the cheapest guy in town and you didn't understand that, well, he cut his fee down because he's not handling anything in the administration part. So an attorney could just say, well, you're only paying me to get you letters, and after that, everything's your job. If you are one of my clients, our contract has nothing to do with dealing with creditors. I do not put that up front on people or have people pay for it because I don't know if there's a creditor at the beginning. If you're wanting my office to handle that, then we are going to bill hourly for that. we will take our time and we'll go through and we'll do everything. You don't need me to do this. This is sending out letters. You can do this yourself. You can send the permissive notices. It's really easy to write a letter and mail it certified to the unsecured creditor if you want to. However, some people just like, well, you know what? I'm the executor. I don't want to deal with it. I'll pay an attorney to do it because I'm going to pay out of the state. Well, you can pay my office to do it. But I want you to understand, we will handle the notice to creditors. We will do the things that are required to do. If you are not going to pay a secured creditor, I need to know this because I need to make sure that letter gets sent. So you need to let us know that you're not paying off any secured debt. We try to get that information from you along the way, but sometimes we don't get that information, and so we don't know. So important point, if it's a secured debt, let my office know because we need to make sure a letter gets sent out. Okay, we understand that we charge that up front, so as part of your fee is I'll send the letter. I ain't going to deal with the creditor though. Creditor starts calling me, I'm going to bill you for the time I have to sit there and deal with them. Because creditors can take hours and hours and hours and hours of my day, and I don't know who I'm dealing with. And I can't charge up front for those type of things. So in any kind of process, I'll send the letter, which is required. Me negotiating out the deal is not required by my office. Now, a lot of times I can negotiate things down in certain circumstances and make my fee. So if that's the case, you might want to hire me to do it because I can save the state more money than it would cost. Just up to you as the executor administrator. I want to remind you, I'm just the attorney. All I can do is help you with the legal court requirements. You are the executor and administrator. That means you have to handle the estate. I cannot handle the estate. I cannot open bank accounts. I cannot gather assets. I cannot do those things because I am not the executor. I can't call a bank. They won't listen to me. You could give me authority to act on behalf of the estate. But once again, we bill hourly for that type of work if you're not wanting to gather things or do anything like that. Hopefully, this was able to explain the concept of what you are dealing with. Let me go once again through the code sections if you want. If you're dealing with a secured debt, it's Texas Estate Code 355.152. The other estate code that you want to know that deals with real estate that requires a mortgage company to file their claim within the deed record, it's Texas Estate Code 305.052. If you're dealing with the notice to creditor, the section Texas Estate Code 308.051. And Google's pretty smart. You can Google any of this and Google's brain will figure out what you're trying to find. So if you just say Texas Notice to Creditors, Texas Estate Code, it's going to pull up the section for you. And permissive notice is under Texas Estate Code 403.051. All right, those are the code sections that you should know if you're going to deal with this. And if you want to go and read them, you shouldn't have to read them after listening to this. You should understand what you need to be doing, which is if you get presented with a claim, you got to deal with it. You can't just ignore it. You got to deal with it. You got to either negotiate it down. If you're going to ignore it, then they have 4 years to file a claim. Just know that's the rule.